Now we'll discuss the third part of the Indian Evidence Act. As the entire Indian Evidence Act is subdivided into three parts, out of which the first part we had discussed with reference to the relevancy facts and facts and issue from section 5 to 55. Then after we had discussed the second part, that is with the proof, wherein we'll discuss the oral evidence, documentary evidence, the public documents, the exclusion of oral evidence, certain presumption under the law so far as the documentary evidence are concerned. And now entering to third part, that is with respect to the that is the rest of the part, that is Indian Evidence Act is in the third part, which is provided again under the chapter and the title called as the procedure for proof of the facts. And this proof of the facts again subdivided into different parts. That is the rest of the topic, that is part 3 of the Evidence Act. The first part is a very important one. Of course, each and every topic is important one, but the chapter we call as the burden of proof. And this particular chapter is provided under section 101 to section 114 of the Indian Evidence Act. Then we'll discuss again very favorite chapter of the examiner, that is with respect to the principle or doctrine called as doctrine of estoppel, with reference to section 115 and 117. It's very interesting aspect is provided. Different kinds of estoppels are there. We'll discuss here one kind of estoppel under the Evidence Act, and then we'll come to the again important aspect, that is with reference to the witnesses and examination of witnesses. This is very lengthy chapters. First we categorize the witnesses right from section 1180 to section 166 of the Evidence Act deals with this aspect. So firstly, under this chapter we'll discuss the witnesses, and then we'll discuss the procedure for examination of witnesses, like under the chapter called chief examination, cross-examination and re-examination of these witnesses. So before we'll start with the other aspect, we'll start with the first chapter from this last part, that is with reference to the burden of proof. Now, what is this concept we call as the burden of proof? First, let us will understand. If you go through the by words, proof we have already discussed. That is to prove. That is the proof. Because rather, if you ask the general person what is meaning of evidence, then they simply say the proof. Something you must have. That is what the title is given, burden of proof. And see the proof, and that is the burden of proof. In legal sense, as a legal students, we may call as the onus of proving the particular facts. In other words, rather. So this chapter that is provided under section 101 to section 114 of the Evidence Act, we are going to discuss here. Now, before we enter into the chapters and the provisions, because it's very easy to understand, because we are subdivided this chapter into three parts that we'll discuss during the course of lectures. But what is this burden of proof? Please bear in the mind, so far as the rules in respect of burden of proof to the civil cases and to the criminal cases are totally different. In civil cases, rule of burden of proof is totally different than the criminal cases. During the various lectures, I have used the word in criminal cases. The rule of burden of proof is that it's a beyond reasonable doubt. Whenever any allegation has been raised against the accused person, or any criminal complaint is filed in the criminal court, then the allegation against the person has to be proved beyond reasonable doubt. Now, what is this concept called as the beyond reasonable doubt? Beyond reasonable doubt means, of course, while discussing these provisions we'll discuss, there should not be a single doubt in the minds of the court. And another principle of the criminal law says, if there is a doubt in the mind of the court, then benefit of the doubt always goes in the favor of the accused person. So this is what the cardinal principle of the burden of proof under the criminal law. That is, it should be each and every guilt should be proved beyond reasonable doubt. See, because the accused is having the another basic criminal law principle with him, that is the innocence, the principle of innocence. Even though charges are laid against the accused person, and during the trial, until the court convict the accused person, it is believed that it is presumed that he is the accused person, and it is the duty of the prosecution to prove the guilt of accused person beyond reasonable doubt. And therefore, in case of the criminal law, the rule is that beyond reasonable doubt, and doubts, if there is a benefit of doubt, the benefit always goes into favor of accused person. And there are several judgments given by the Supreme Court and High Courts of India also. So these kinds of aspect we'll discuss so far as the criminal law is concerned. Come back to the civil cases. In civil cases, as we discussed in last lecture also, the rule is not beyond reasonable doubt. The rule is, we call as the preponderance of probability. That means if there is a chance of probability, ifs and buts is allowed under the civil proceedings also. So the party has to just nexus between the two fact and issue, so that ordinary prudent, here the ordinary prudent man theory came into picture. So the ordinary prudent man will be believe that certain thing will be in a position. Like one of the example we had discussed, that if suppose there is an oral contract between the parties, and on the basis of oral contract, by cash any party has paid the other party, that is the owner, the earnest money, some of the or half of the money of the transaction, and the owner has put possession to the purchaser, and subsequently owner denies. That presumption, that possession will speaks about the probability. If suppose tomorrow the owner denies that no, such kind of contract was not existent, because the other party is not having proof. Neither there is a written document, nor there is any certain proof is with him, because he paid the amount by cash, and now the only proof is the possession. So if he come with the story, sir, see the ordinary prudence man theory, why he put me in possession. So in that case, in civil cases, these kinds of ifs and buts are allowed, which is not available in the criminal cases. In criminal cases, the prosecution has to prove the guilt of accused person beyond reasonable doubt. So this is the base of the what is we call the burden of proof. There are several judgments which provided under the title of the burden of proof, but one of the judgment which is very important under the Indian Evidence Act, that is we call as the Narayani versus Gopal, wherein Supreme Court has given certain guidelines. In this case, the Supreme Court held that burden of proof, the concept of burden of proof is of the two aspects. One, sometimes the party is required to prove the allegation before the judgment, and other one, it also means that if there is a contrary issue arising between the parties, it has to be introduced in the evidence. So based upon this, the classification, we will discuss what is this burden of proof and onus of proof. See, please bear in the mind, in a law, whether it is civil or criminal cases, the burden is always constant. What is changed is the onus. So burden is constant, onus is change. Now what is this burden constant, onus change? I hope you remember the example which we are discussing in the class of that dead body. But here again, with the cost of reparation, let's discuss one thing. Now, while discussing last chapters, we have discussed that, let us take the same example. A agreed to sell the house to the B, and the price of the house is fixed for 10 lakh rupees. They have entered into registered document. Registered document is registered. 5 lakh rupees paid, and rest of the 5 lakh rupees will be agreed to pay at time of final documents. Now, on the day of the last day of the agreement, that is the contract, A went to the house, required him to perform his part of the contract. B refused. Then he went to the lawyer. The A went to the lawyer because he wanted the agreement to be performed, and he narrated all the things. A smart lawyer who understands the concept and aspect of the all the aspects, what he has done, he asks his client, what do you want? He says, sir, I want my house and I'm ready to pay rest of the 5 lakh rupees out of 10 lakh rupees. A lawyer, while sending the demand notice, he's saying, along with the notice, he's saying the demand draft of the 5 lakh rupees in order to show ready willingness. Notice saying, demand draft saying, but the B refused to perform, and therefore they file a suit for specific performance of contract. So, suit is filed, summons is served as per the order 5 of the CPC, and defendant appear as per the rule. Defendant, that is the B, that is the owner of the house, he has to answer the suit of the plaintiff, and that answer we call as the written statement in the eyes of law. So we file written statement. Here we are discussing the entire evidence act. Let us analyze everything. So while answering the each and every para, because order 8 rule 1 and rule 2 and 3 says that there should not be evasive reply, it should be specific. So in para number 1, plaintiff has put that the description of property. Secondly, he has mentioned there was a contract. Third, etc., etc. So while answering the para wise, Mr. B has said, yes, the description of the property is correct. That means it is not disputed fact between the parties. The house number, the area, everything is correct. Secondly, he mentioned that there was a contract. In para number 2, the plaintiff mentioned there was a contract between me and the defendant. And now he agreed to sell the house, which also accepted by the B. Now I will take a pause here. Why I am saying this? Because one of the sections of the Evidence Act, that is, it says that facts admitted need not be proved. So these are the facts. But what is fact in issue? Now in third para, plaintiff mentioned that the price of the house is fixed 10 lakh rupees, out of which 5 lakh I have paid, and rest of the 5 I am ready to pay. But now to this story, to this statement, defendant, that is B, says, sir, this statement is absolutely wrong. I am not accepting this statement because the price of the house is not 10 lakh rupees but 15 lakh rupees, and that's why I am not ready to perform the contract. This is the reason I am not performing the contract. Now I will take a pause. Now it's a fact and issue. The fact and issue will be that whether, because see, two facts he has admitted, description of the property admitted, contract is admitted, or registered document is admitted. See, on those facts which are admitted, there is no need to frame the issue. And therefore, the only one issue will be here, or there might be two issues. I will add another issue, that whether the price of the house is 10 lakh rupees or 15 lakh rupees. Now, B, in addition to his written statement, he has mentioned that, sir, why you are putting the 10 lakh rupees? So that A has requested me that if you mention the 10 lakh rupees in the agreement, he has to pay the income tax over the 15 lakh rupees. So what we will do, we mention here 10 lakh rupees and we'll execute one notarized document and where we will mention 15 lakh rupees, and in front of two witnesses, Mr. X and Mr. Y, he has accepted that the house price is 15 lakh rupees. So he comes with another story. So the issue in the case, that is we call as fact and issue, will be whether the price of the house is 10 lakh rupees or 15 lakh rupees. I will take a pause here. Secondly, whether the defendant proves that, what he proved that the price of the house is 15 lakh and not 10 lakh, and 10 lakh amount is mentioned in the agreement to say only because in order to avoid the payment of income tax. I will take pause here because this issue itself is the opening door of this section. Now, the moment this particular issue has been framed, party has to lead their evidence. Party has to submit their evidence, and the first duty is cast upon the plaintiff. Now, plaintiff appear, he filed his evidence affidavit in the court of law, and along with evidence affidavit, he filed documents, because whatever evidence you have to file in the court of law. Fortunately for the plaintiff, he has an original agreement to sell with him, and he is submitted in the court of law. If he is not having the document with him, and document is in the possession of the defendant, then he has to apply the procedure under section 66. That is, he has to issue the notice to the plaintiff, and he has asked plaintiff that the document is in your custody, you file it. If he file it, there is no question. But if he refuses to file, then he is allowed to produce the secondary evidence. This aspect we have already discussed. That's what I'm saying. We are going to discuss the entire evidence act in one example. So he has, for the sake of convenience, he produced the document on the record. Now I will take a pause. Here, if the original document is produced and that document is a registered document, it gives the presumption. Just two lectures back we discussed the presumption document. If it is a registered document, 65, 64, 65, if it is the original document, it is registered according to law, then court shall presume unless contrary. It is a presumption. It is a rebuttable presumption. It is a rebuttable presumption. Of course, it is not irrebuttable presumption. It is a rebuttable presumption. Court shall presume that it is genuine unless contrary is proved. Now he filed. He was cross-examined. The moment we use the cross-examination, we directly jump to the last chapter of Evidence Act. That is examination in chief, cross-examination, re-examination. The examination of the plaintiff is over. Now come to the party of the defendant. Defendant appear. He filed his evidence affidavit and he showed to the court, sir, no doubt registered document is there. Presumption is against me because he has a registered document. But see the sir other facts. And therefore, I'm coming to a very important aspect. Some of the students, they are under impression that only because there is documentary evidence, all the oral evidence are excluded. No. See the language of the law. It says only the contents of documents cannot be proved by the evidence. But the contents in the documents can be disproved by the oral evidence. Please bear in the mind. To prove the contents, document is required. To disprove the contents, oral evidence is allowed. This is the basic principle of the law. So, he come with the story, sir. No doubt this document has mentioned 10 lakh rupees, but kindly accept my story. Let us go with the facts. Sir, I will prove how the house price is not 10 but 15 lakh rupees. And in order to show this aspect, what he has to, he has brought the government extract, the government valuation of the property, and he says, sir, in the year 2019 I agreed to sell the property. Let us see what was the government price at that time, and government price shows 14,50,000 rupees, for example. I am on the point of corroborativity of the evidence, corroborativity of the statement. One hand registered document, one hand presumption, other hand oral evidence and certain documents on record. He further stated, sir, generally, ordinary prudent man will not sell his house to the less than government value because plaintiff himself accepted the title of the property is clear. If the title of the property is clear, what is the necessity? Why I would sell my house to less than 15 lakh rupees if the government value is 14,50,000 rupees. See the price. The weightage of the statement will be higher. Then he'll say, sir, not only this, after registration of document or on the same day, he has executed a notarized document in my favor. And in that document, it is categorically mentioned by the plaintiff that the house price is fixed for 15 lakh rupees, but only to avoid the government tax, we have mentioned the 10 lakh rupees. This is admission. This is admission by the plaintiff. And after examining him, after producing all these two documents, the defendant examined two witnesses who were the witnesses to that registered document. I'm sorry, the notarized document. They deposed, yes, it was agreed by the plaintiff that the price will be 15, but in order to avoid the taxes, we will mention that amount. Oral evidence disproving the contents of the documents. This is the nicety of the Indian Evidence Act. Therefore, if the other party is come with the bulk of documents and you don't have documentary evidence, don't be afraid. It's a skill. It's a skill which is provided by the Indian Evidence Act, and that too with the burden of proof. And therefore, let us discuss what are the basic rules. The basic rule is provided under the that is part 3 of the Evidence Act with the title of burden of proof. And the first rule, that is the basic principle of section 101, says that burden of proof, on whose burden lies? It simply says, he who desires. The wording is that he who desires that the judgment should be given in his favor, the burden lies on his favor. See the nicety. What the rule say? It says when anyone wants that the judgment should be given in his favor, that person has to prove that burden lies on his person. See, in this our case, plaintiff is saying that he's entitled, initial burden lies on his shoulder, and if he shifted, that is, if he shifted onus, then onus will be shifted on the defendant, but burden lies the person, or he who say judgment should be given in his favor. So this is the basic principle of law under section 101. And you know what, this principle itself based upon the Latin maxim, that is incumbent provision of qui quesit and non qui negate. It means in simple language, this is what the Latin wordings we have used. It means the burden of proving of the fact rests upon the shoulder of the person who substantially assert that judgment shall be given in his favor, and not the person who denies it, who say that affirmative facts has been given in his favor, that on his favor the burden lies on the person. I'm not talking about the onus, I'm talking about the burden. And therefore the concept of burden of proof has two meanings. One, that it's a burden, natural burden on the party to plead the facts, and secondly, it is evidential burden. There are two facts, there are two burdens. One is the evidential burden, and second one is the burden, what you call the pleadings burden. So in the burden of the pleadings, the party has to plead in a chronological manner what is the pleading, what do you want to say. Whereas in case of burden of adducing evidence, the party can shift the onus by examining the witnesses, like we have already discussed. In case of the person who want to judgment in his favor, he can adduce the evidence to prove or to disprove the facts of the particular case. Then we'll proceed to the next rule, that is with respect to the onus, that is on whom the onus is lying. Section 102 deals with this aspect, that even the title is that burden on whom lies. As I have discussed, that the burden constant, onus is shifted, and therefore shifting of provendi, this is what the word they have used under section 102. So what is this shifting? That he who commits the case, initial burden lies on his shoulder, and the moment he rebut it, that is, the moment he proves certain facts, it will be shifted to other party. This is called as the shifting of onus from one party to another party. And section 102 lies on this part, this aspect, and it simply says negatively, he who failed to give the evidence, onus is lying on him. That means, if suppose someone made an allegation against you against the party, and other party has failed, it's one kind of acceptance from the other party. This is what the section 102 has said. It specifically deals with the onus, and the onus, the basic principle under section 102, I'm sorry, 101, and the onus lies on the party. This is what the difference between 101 and 102. Whereas section 103 deals with the burden of proof on the particular cases. So 102 and 101 apply to the general cases, while 103 is applicable to the particular cases. There are certain particular cases. This is rather exception provided to the 101 and 102, that the party 103 provides that the party who wish that the court should believe the existence of certain facts, or as it is provided in the proceeding, that is we call it the pleading of the party, then under section 103 the party has to prove the certain or the specific facts. Like I will give the simple example. Under the Hindu law, that the jointness of the property is a presumption. It's a presumed by the law. So once it is a presumed that the jointness of the property is presumed, that HUF we call it Hindu undivided family, and if any party, any person, he come with the court and with the story that yes, already partition has been took place, this is called as a special kinds of the burden of proof on the party. In such case, the party has to prove how the family is not HUF, that is Hindu undivided family, but it is divided by the act of the parties, by the operation of law. Then in such case, in case of the specific aspect, he who come with the case, he who want to prove something special, the burden lies on the party to prove how his case comes under the section 104. This is what the another rule, which is the exception to section 101 and 102. While the 104 again deals with the same kinds of the provision, which provide that the burden of proof to prove the evidence is admissible. Now again, this is the basic rule. If someone come with the case that to prove his case this particular evidence is required, the burden lies on that particular person to prove. Like we are discussing in the case that we say that it's not a registered document which is admissible, but this notarized document is material. In that case, onus shifted on the defendant, that is the B, to prove how that particular document is material in order to prove the particular case. This is what the provisions of section 104. In short, section 101, 102, 103, they are dealing with the general rules, while after the 104 to 114, they will deal with the particular aspect, wherein 104 says that whenever any party wants to prove certain things, he has to prove the other facts. Like for example, let us take an example that if suppose any person wants to prove that the dying declaration should be admissible as an evidence, in that category, in that case, the party who wants to prove the dying declaration, he has to prove first that the person whose dying declaration is want to prove, he is dead. So firstly, he has to prove to the court that the person whose dying declaration is admissible evidence, that person is dead and gone. So firstly, initial burden lies on the person to prove death of the person. If death is not proved, dying declaration will not be admissible in the eyes of evidence. So this is what section 104. So herewith we are discussing the special kinds of the burden of proof. In case of this particular facts, the person has to prove the particular fact has in existence. Like in case of dying declaration, death has to be proved. Secondly, under section 105, if suppose that this particular 105 specifically deal with the general exceptions under the Indian Penal Code, especially section 76 to 106 of IPC, it provides that we have already discussed the provision under section 10, that is 76 to 106. See, under the criminal law, I will give the example how section 105 came into picture. Say for instance, A stabbed B, and he stabbed B with the help of the knife. At that particular time, when he is committed murder because stabbing, and as the result B dies, that time there are 4 persons, those who are eyewitness to the incident. They are watching the incidents, and after stabbing, A ran away. Now you are not aware who is A, who is B, but still, as the basic principle of criminal law, anyone can set the law in motion. A called the police officer came and they registered the FIR. After registration of FIR, they record your statement, and you are one of the eyewitness to that incident. Eyewitness means the person who is present at the time of the incident itself. So you are one of the star or eyewitness on that particular case. You are deposed before the court. Sir, I am going to the college to my house. At that time, at say 10:30 on so and so date and so place, that A came and he took up the knife from his pocket and he stabbed the B, and he stabbed 2-3 times. As a result of heavy bleeding, he dies on the spot and we can't help him, and accordingly I call you and you register the FIR. So you become one of the witness. Now later on, the police officer arrests the accused person. The further investigation has been carried out. Charge sheet has been filed under section 173 subclause 2 of the CRPC. The trial is going on. Now sometimes question your mind that if everything is there, eyewitnesses are there, then why the trial is required? But see the basic principle, the guilt has to prove beyond reasonable doubt. Now another principle of the criminal law, that innocence of the accused person and burden of proof, just now we had discussed. It's a duty of the prosecution to prove the guilt beyond reasonable doubt on the accused person, and accused has to do nothing. He has to do nothing. So what will the prosecution will do after filing of the charge sheet? As per the session trial, as provided in the section 225 to section 235 of the CRPC, they will start examination of their witnesses. In that case, they may examine you also as a witness. You depose. The moment you start examination, then the defense lawyer, that is the accused lawyer, will take your cross-examination, and your examination will be over. So, under the criminal law, what I am pointing you, that there is no need to accused person to prove his own case by stepping into witness box. He can disprove the prosecution case. So there is no rule that accused has to step into witness box as it is in the civil cases. So it is a duty of the prosecution to prove the criminal cases. However, the moment accused person say, my case is fall under the general exception and not the basic rule provided in section 107 to 511 of IPC, in that case, onus shifted from the prosecution to the accused person. This is what section 105 says. The moment accused person says his case is fall under the general exception, onus shifted an accused person. Otherwise, basic onus lies on the prosecution. In that case, the accused person may say to the court, sir, that act is done under the heat of the passion, or he may come with the story, it's a grave and sudden provocation, like we have already discussed under the IPC, or he may say it's an act under the right of private defense of the body or the property, or he may say this is the act under the insanity. Whatever evidence, whatever defense, as provided in section 76 to 106, the accused person may kindly take under the 100 section 5 of the Indian Evidence Act. But the point is here, the moment accused says that his case comes under the general exception, the onus lies on the accused person to prove how the onus will be, how his cases fall under the general exception. Then come to the section 106. Now, 106 is again come with the burden of proof in case of the fact, especially with the knowledge of the particular person. Now, I am using the word facts within the knowledge of the person. Now, if the prosecution came with the story that the person has committed the act with a particular intention, then again the onus shifted to the prosecution. Let us take the same example because the word is used especially within the knowledge of the accused person. Say for instance, in same case, while examining the witnesses to show the intention of the parties, when the police officer examining what was the intention to commit a murder, then the wife of this deceased deposed before the police officer that, sir, might be because of the 3 months back there was a quarrel between my husband and the accused person, and therefore in order to take the revenge he might have committed the murder. So especially within the knowledge, section 106 says whenever the person come with the story that act is committed with the special knowledge, then burden lies on the person who has to come with the that particular story. Same in case of section 107. Section 107 deals with the aspect that this is one kind of the presumption also, that it is in respect of the presumption of the death or presumption of the aliveness. Now this is something interesting. Section 107 provides that if the person, section 107 and section 108 deals with the certain kinds of different aspect, that is in respect of one kind of presumption. 107 says if someone says the person is dead, I'm using the word, and if any person comes with the story that no, he is alive, that criteria is for the 30 years. So in case of the aliveness, the matter is 30 years, whereas exactly opposite to section 108, it says whenever a person is not heard for the 7 years, this is called as civil death. Sometimes when you enter into practice, client will come into you and say, sir, my relative, my father, my husband, whatever it may be, he is not found last 7 years. I have lost this missing complaint. Kindly declare the order, take the order from the court, that is called as civil death. Then it comes under this same. it's provided that if any person who is not been heard for 7 years. Now in 107 it's 30 years. Here it is 7 years, and it has not been heard by 7 years to the person who has naturally heard. That is, naturally heard means either their his family members or friend. If they came with the story that the person is not heard within 7 years, and any person who says no, I saw him last year, the onus is lies on that person. So one kind of presumption is provided under section 107 and 108. So the 107 and 108 has to be read together. One is in respect of death, or other is in respect of the aliveness of the person. So it's a presumption of the death in case of the section 108. Under section 108, the court will presume that the person who is not found for 7 years, he will presume to be dead unless contrary proved by the party, and he who come with the court, that is, I saw him, the onus will lies on him, how and when and where he has shown or seen the person who is declared to be dead in this case. Come to the next aspect, section 109. Again, this is the special categories of the aspect. This is in respect of the business transactions, especially the partnership, landlord and tenant, and the principal and agent. So whenever in any case, that's what I'm saying, that after section 104, this is a special rules. Whenever in any case the question is arose whether some person is the partner, whether some person is the tenant, whether some person is the landlord, whether some person is the principal or agent, it has to be shown not only by the record but by the conduct. I will give the simple example. Now let us see the example. Suppose A is the owner of the house, and he has let the house to Mr. B, who is staying there. And suppose tomorrow some dispute arose, and A filed a suit against the B, that is, the landlord filed a suit against B, and he came with the story, by fabricated story rather, that B has illegally staying in my house. He has no authority to stay in my house. He is illegally staying. He is illegally encroaching my property. Whereas B comes with story, sir, I am the tenant. And if suppose the question of the relationship itself is arose, then burden lies on the party to prove the question under section 109. Then the tenant may say, sir, if I am not the legal tenant, then why he would have not raised a complaint last so many years? So this kind of presumption is there. Same in case of the landlord and tenant. Say for instance, like in case of law of agency also, you must have been discussed the example, like A appointed B to collect the rent from the C, and every month B is collecting rent from the C, and say for instance, even after collection of the rent from the C, B has not paid A, and therefore A, without inquiring to the B, he sent the notice to the C, non-payment of the rent, and therefore C came with the story, I have paid the rent to the B. In that case, the B, A cannot deny the relationship of A and B. In that case, the court can draw the presumption in respect of the partnership also. The act of the partner is binding on the other partner. This is what the basic principle. Same in case of the landlord and tenant. Same in case of the landlord, the principal and agent relationship, as it is provided under the Indian Contract Act, especially the section 182, section 238, 236 of the Indian Contract Act deals with all these aspects. Now come to the very important aspect, and when you enter into practice, these kinds of aspect came into picture, that is section 110, burden as to ownership of the property. Now when the question is arose in respect of ownership of anything and possession of the property, because this particular aspect came into picture when the possession is with one person and ownership is another person. Again, the problem of this case lies in the jurisprudence, because jurisprudence says the possession is 9 points in the law. That means he who has a possession, he has a title. Rather, it is said, always say, possession is a good title in the eyes of law, and nothing lays against the all but the true owner. So someone claiming that the person illegally in possession, the onus lies on the person, how he is illegal in possession, because there is a presumption he who has a possession, he is the owner of the property. So 110 a very useful in respect of the uh, so far as the evidence act is concerned, and when you enter into practice, these kinds of aspects will be very useful, uh, especially section 110, in order to prove the ownership and the possession of the property. Now we'll proceed with the last chapter from this section, and you will realize under this chapter itself certain presumptions are provided, like we had discussed at the time of discussing the presumption of the documents, that certain presumptions are available under section 111 to 114. Now this is very interesting, and this is the right time rather to discuss this particular aspect, especially 111. There are certain presumption of offences are provided. 111a rather, it says like this is like nowadays, because of the corona, the police commissioner has order for the curfew. One kind of curfew order has been there, where the person cannot move freely. This is a restriction of freedom of move, freedom of liberty. And 111a provide that if any person, now this has happened, you are watching on the TV, you are reading on the newspaper and social media also, that the police officer has directly lodging the FIR against the accused person without making inquiry. Now how come this is the section, this is the perfect time to discuss this section. It says that if any person, when there is a order is proclaimed by the police officer, and that particular person is without any reason wandering from that particular area, then law presume that he has committed certain offences, and therefore nowadays thousands of the offences has been registered against the accused person, or even though they are going for the morning walk, they are going for the certain area, because of the proclamation of the order by the police officer, that is the curfew, that is law and order has been described, that is by the particular police officer. This is one kind of presumption under section 111a. Second presumption, which is most important, and the onus is lying on other party, that's in case of 112, birth during the marriage and conclusive proof of legitimacy. Very interesting, and most of the family matters, section 112 came into picture. That most of the time it happens that most of the time by the father, that they say the child born out of the wedlock he is not the father of that child. He is the someone else is the father of that child, and therefore most of the time in the practice, when we enter into practice in the family courts or in some civil court, the father make an application for DNA test of this small baby to identify who is the actual father. Nowadays that is different aspect, but just to academic discussion, now that the Supreme Court has banned this DNA test because of the procedure, lengthy and very technical procedure, and the rights of the baby, small baby. Therefore DNA test has been stopped by the Supreme Court because of the order. But 112 deals with a certain presumption, and it says that when if the child is born during the continuation of marriage, this is most important. There is a continuation of a valid marriage between his mother and the father, or with the and within the days are most important, 280 days, that is 280 days after the marriage, then or after dissolution of the marriage. See, if during the continuation of marriage or within the 280 days after the separation, then law presumes that the child, that it is a conclusive proof that it is a legitimate child of that person, and he who say he is not a father, onus is shifted on this particular school, but not beyond that 280 days formula. So that 280 days, why? Because that is the period for the pregnancy and delivery. Therefore the criteria is provided in under section 112. Whereas the 113a, this is very interesting aspect. When going to the practice, there are certain presumptions provided under section 113 A of the Indian Evidence Act, that when you need to go to the practice, that this is an amendment carried out. It provides that whenever any married woman commits a suicide within the 7 years of her marriage, then law presume that she has committed the suicide because of the cruel treatment given by her relative, that is husband or relative of the husband. This is one kind of the presumption is provided. Same in case of the B also, that is presumption of dowry death. And if it is within 7 years, then law presume that the aspect is for the dowry or demand of the dowry. These provisions have been amended along with section 498A in the year 1977. That time dowry and cruelty is very crucial as issue. Fortunately for our generation, now it has been reduced, especially if you know the judgment given by the Supreme Court in Ernest Kumar, that the 498 criteria has been changed, and nowadays because of the education, because of the so many aspects, now this particular offenses, the offense has been reduced. But since it is a syllabus, we have to discuss this now. Apart from this, the last section, that is section 114, which is very important, that court may presume certain facts. The list is provided in section 114, and which is very useful list, because when you enter into practice, very important aspect is being provided, especially 1, 2, 3 aspect is very interesting. It says that subclause A is very interesting. It says whenever a man who is in possession of the stolen goods, and he is not in position to explain how the goods is in his position exactly after the commission of offense of theft, then police officer may presume that he has committed the theft, or either he has received the good with the knowledge that it is a stolen property. This is what the presumption is that. So this is presumption. Secondly, most importantly, that an accomplice is untrustworthy of the credit. Now, what is this accomplice? Now, accomplice is the person, and see the title. Accomplice is the untrustworthy of the credit. Who is he? Accomplice is the person. Accomplice is the person who is associated to commit the crime. See what happened in most of the crime. Those cases which are based upon the circumstantial evidence, section 3, where there is no eyewitness in existence. The case is based upon the circumstantial evidence, and the police officer later on arrested the accused person. And let us take the example: the accused person has committed the offense of death with murder. I'm sorry, the dacoity with the murder, and this is a serious offense. And in that case, one hand the law says that the guilt has to prove beyond reasonable doubt. Other hand, the problem of the police machinery is that they don't have direct evidence. There is no absence of eyewitness. There is absence of eyewitnesses. There is no clue, nothing. Therefore, the police officer generally use the trick. What is that? They during the interrogation, I'm not saying investigation, during interrogation, they check out who is the weaker accused person, and they, by using the trick, they take the person, or they might use the trick. They ask the accused person, see, other accused is saying they have done nothing, but it is you who has done everything. And if suppose that accused person, no sir, I have not done nothing, I am just waiting in the car, they are saying against me, I will show what I will tell you what has happened actually. So he tried to tell you everything, and he become the prosecution witnesses. So he become the prosecution witnesses. So this particular aspect is important. So this is one kind of intimation to the court that it says accomplish. He is accomplished. Why? Because he joined the hand with the while committing the offense. But the moment when the prosecution is there, he turned hostile and he joined the prosecution. So he is untrustworthy of the credit, because he is neither the witness, he is not continue with the accused person, not to the prosecution, and therefore court has to see his credit very carefully. And then come to the last aspect, the next aspect, that another presumption is that the judicial officer or the officers, they are performing official duty officially. This is another presumption court has to take into consider. And most importantly, the E, that is most important aspect, that person having the evidence, if he is not producing the evidence, the court shall presume that he is not producing that because it goes against you. This is most important aspect so far as G is concerned. Why? Because let us take the example, the beginning we had discussed, that if suppose B come with the story, sir, after this registration document, A has executed a notarized document, and that document is with me. If having the document, if the person is not producing document in the court of law, the court believe that that person is not producing that document because it might be go against you. This is one of the characteristics of the section 114 Act of the Indian Evidence Act. And recently there is another rule, or there is another section has been added to this presumption as to abuse of the absence of consent in certain prosecution cases. This amendment has been carried out in respect of the offences of the rape, and they say in case of the woman, when the woman is in such a position that she cannot oppose, in that case court can presume that there is an absence of the consent, because in case of rape offences the consent play a vital role, and if there is a offense of rape is committed under clause 376 A, B, C, D, E, F, G, H, then the court can believe that there is the absence of consent of that particular lady, and it has to be presumed unless contrary has been proved. He who say there is a consent of the woman, the onus is lies on the person how and when the consent is lies on the person. So this is all about the burden of proof chapter. It's very useful, and it's very important rather, examine point of view as well as the practical point of view. Thank you.